Hello, everyone, and welcome to another episode of Tune In with Trevor. Today we're interviewing one of my legal heroes, brilliant jurist, scholar, Alex Kozinski, who has had quite a career. You were number one in your class at UCLA, and you came from Romania. How did you end up having this remarkable career, becoming a judge on the Court of Appeal and doing as well as you have?
Well, when I came to America, I spent, I would say, about 5 years basically glued to a television set, absorbing American culture. And the show, I mean, I Love Lucy, all of that stuff. I watched everything. But the stuff that stuck with me was the legal stuff. 12 Angry Men left a deep impression. I mean, I remember the scenes in my mind, and I saw it again 20, 30 years later, and I remember everything accurately. Mm-hmm. And then there were other shows, Day in Court, Divorce Court. I watched it all, and it fascinated me. So when I went to college, my parents thought I should be an engineer. Mm. They were both Holocaust survivors. And I said, engineer? He said, well, you know, when the next Holocaust comes, the lawyers and accountants, they're going to be sent off to gas chambers, but they'll never get rid of the engineers. They need the engineers. So I tried for about a year and didn't cut it. So I became like a political science or economics major or something like that. And then faced with graduating and having sort of no skill that would earn me a living, I didn't, I was trying to figure out what to do. I can't stand the sight of blood. I already proved that I can be an engineer. So what was left? Law school. So I went to law school, and I thought, well, now this will be a nice job. Well, I'll get up and I'll be like Perry Mason and I'll object, irrelevant, incompetent, and immaterial, Your Honor, and all that. But this was 1972, and there was quite a slump in the legal profession at the time. And I remember reading in this article in one of the publications that it was called Juris Doctor. It was circulated to law students. And they said, you're going to have a hard time getting a job when you graduate, and they gave sort of tips of what you can do. You can maybe join the FBI. They still require either an accounting or legal degree, or you can sort of go to print up a resume and go knock on doors and try to get people to interview me. So I remember I read this in the student lounge, and I remember sitting there for a long time and thinking, if you have to be, they said basically if you're finishing top 10% of your class, you'll probably do okay, but otherwise you're going to have a difficulty. I had never been good at school. I've always been mediocre. My mother, Holocaust survivor, said, be mediocre. The guy at the front of the line, the guy at the back of the line is getting picked off. Be in the middle of the pack. So I never tried very hard. But right there and then in the student lounge, I decided, if you have to be top 10% of your class and law review to get a job these days, here I'm a little Jewish kid with a thick accent, I need to be first. And I just decided right there and then I did nothing else for the next 3 years. Nothing else but study law. And you enjoyed it, I take it. Yeah, I cried the day I graduated. I actually sat there in my cubicle and I shed tears. It was great stuff. I enjoyed every minute of law school. I enjoyed the lectures. I enjoyed arguing with the professors. I even enjoyed the exams. It was great. And then what kind of work did you do after that? Well, I was going to go to a law firm, and I was all set, but in the spring of my senior year, one of my colleagues, one of my classmates came up to me and said, I just came back from an internship with Judge Walls on the Ninth Circuit, and I heard that the President Ford, has appointed a new judge to the Ninth Circuit. His name is Tony Kennedy, and people think he'll amount to something.
Oh,
You should apply. So I checked with my sort of professor mentors, and they said, yeah, go ahead and apply. So I sent off a letter, and they sent letters of support, and I got a call a couple of days later and says, come to Sacramento. And so I flew up there on Western Airlines. I remember
the only way to fly.
the only way to fly. And I remember I got off the plane, and these were the days when you can come to the gate without going through security. And there was this youngish guy waiting for me, and he says, "Hi, I'm Tony Kennedy." And I got the job. So after that,
And Anthony Kennedy, of course, went on the United States Supreme Court.
yes, of course.
We were getting there.
Well, I guess I don't know if everybody in the audience would know that, but I assumed lawyers would anyway. So, yes, he did. We were colleagues for a while in the Ninth Circuit, and then he went on and became a very famous justice. And having sort of gotten on that track, I then applied to the Supreme Court next, and I got a clerkship with Justice Douglas,
Really?
who was the most liberal justice in the history of the Supreme Court at the time, and maybe still.
He once tried to give standing to a tree.
That's right. Many trees. 8 trees, yes. And then joined the bombing in Cambodia, among other things. So I got the call. I remember I was then clerk in the Ninth Circuit. I got a call from the guy who had interviewed me, Jerry Falk, had interviewed me for Douglas, and he says, "Congratulations, Alex. Over the weekend, the justice picked you to be his law clerk." And I said, "That's great." And I made phone calls and told my friends and all that. About 3 hours later, the phone rings again. It's Jerry Falk again. He says, "I have bad news. The justice just resigned."
Oh, no.
Yeah. So I still had a bunch of applications into the other justices, and I eventually got the clerkship with Chief Justice Berger.
Yeah.
Wound up being co-clerks was Ken Starr, and some of my other, Ken and I clerked for Berger, but Diane Wood, Judge on the Ninth Circuit, Chief Judge of the Ninth Circuit, Seventh Circuit rather, was one of my co-clerks, and Jerry Lynch from the Second Circuit, that eventually became the Second Circuit. Bob Mayer, who was Chief Judge of the Federal Circuit. All
Wow.
happened to be there at the same.
Let's hear about what it was like to be a Supreme Court law clerk.
Not as good as being a Ninth Circuit law clerk. That was really an ideal job. I had there were Judge Kennedy.
In Sacramento, you were.
In Sacramento, yeah. And my co-clerk and I, and that was basically the legal team. And so we interacted with the judge every day, all the time, back and forth. Clerking with the Chief Justice was a much more formal, distant relationship. You had to sort of write memos, and then you had to sort of see him when he had time off from other duties he had, like he was meeting ambassadors, and he was meeting with the Smithsonian Board. He was a Smithsonian Board, and then he had the administrative duties of the Chief Justice and so on. So you had to sort of find the time to actually talk to him. My co-clerks used to make fun of me. They would say I'm the buzzer, because I would sort of hang around the door and just sort of hang around in the corridor looking for a time to slip in and talk to the Chief Justice for a few minutes. Chief Justice was great. When I did get to, when we did get time to talk to him, very reasonable, very understanding, and but you had to make out your
Did you
case fast.
feel that you were influential in his decisions?
It's hard to say. I mean, I wrote bench memos and then he wound up voting. I can't tell how much my bench brother influenced him. I do remember one case where I told him to go one way, and he went the other way, which did occasionally happen. But worst of all, he took the opinion to write. So I had to write this opinion that I thought was totally wrong. And I remember, I drafted it, and the Chief Justice, we went back and forth. But, basically it was the draft, more or less the draft I had circulated, but, with changes. But I had no confidence in it at all. I thought, this is wrong. But this was before electronic, so opinions were circulated on foot by messengers. So it was circulated like 11 o'clock. By 4 o'clock, we had 3 joins. So there was still one. You needed 4 joins to make a majority, and then shortly after that, the dissent came in. It was devastating. It was just took the opinion and plucked it apart limb by limb. And I saw it and I blanched and I said, there goes a majority. And then bam, bam, the other joints came in within minutes. So this is not a famous case. This is not a case you would recognize or anybody out there would recognize. So I'm not speaking out of school here. But it does illustrate the different workflow at the Supreme Court from my experience in the Ninth Circuit when I was a clerk. Nobody ever changed votes after conference to go from a majority to dissent or the other way around. I saw a couple of people, a couple of justices add concurrences or drop concurrences, stay on the same side. But there was not the same sort of give and take.
What were the hours like at Ninth Circuit and at the Supreme Court? I always heard that you just worked around the clock.
I did. But that was me. I was already had worked around the clock for 3 years in law school. I was unattached. So I didn't, many of my co-clerks had spouses and, had real lives. I didn't really have a real life. So to me, my time clerking was a privilege for me. And every minute I spent working on the stuff I was privileged to work on.
What happened to you after that? Where did you go?
I went to a small law firm in... I didn't want to go to a big firm, and I went to a small law firm in Century City doing transactional work, and decided really what I wanted to do, it wasn't really what I wanted to do, I wanted to be an appellate litigator. No one had ever heard of that. I remember asking around town here in LA, and there was just one law firm who was doing that kind of work. I think it was Hurwitz and Levy at the time, still is, they're still around. But most people said, no, we don't hire appellate litigators. There's no such thing as an appellate litigator. I just thought since my 2 years of appellate clerkship, that would be natural. So my wife and I decided we need to go to D.C. and do it. And there'll be more opportunities there. And so we both sort of interviewed D.C. firms. She's a lawyer too. And she got like every job offer for every job she applied for. I got one offer. Covering and Burling said, well, and I interviewed all the sort of big firms. And they said, no, we don't do that. You're just, we don't divide work up that way. You can't be an appellate litigator. Covering and Burling said, well, we've never heard of such a thing, but we're willing to give it a try. But if you don't get enough appellate work, you'll get to work on whatever we give you. It worked out great. There was, once people heard there was such a thing as an appellate specialist.
You got plenty of business.
From the firm, from inside the firm. People said, oh, it's great, I've got trial work to do, I've got all this stuff, depositions, stuff like that. It's good to sort of get somebody who can handle the appeal on other cases, it's a different pace. And of course, these days, being an appellate litigator is quite a respectable
And then you
specialty.
went on to become, if I'm not mistaken, a judge.
Well, from coming to Berlin, I joined the Reagan campaign, and I was in the White House for about 6 months, and I got a job with an agency. I was special counsel of the Merit System Protection Board. The guy who just got fired. And after that, I got appointed to be chief judge of the new, what is now called the Court of Federal Claims.
Right.
Became a trial judge with no experience whatsoever.
And you were young.
I was 32.
Wow.
I was 32, and I spent 3.5 years very interesting cases, case for case. The Court of Federal Claims has more interesting work because the defendant is always the U.S. government in that case, and very interesting issues, constitutional law, takings cases, federal contracts cases, tax cases, very significant and complex tax cases, patent cases.
Well, back to engineering.
Yeah, back to engineering, yeah. So, and from there I got appointed to the Ninth Circuit and stayed there for 33 years, 35 years.
Wow, I know. And you've had many interesting, famous, and for some infamous cases. But let's get into, this is entertainment central right here, this town. And copyright and theft of idea cases, I'm sure you saw many of. Tell us about how many of those were good, or what was bad about them. Talk about those kinds of cases, please.
Well, intellectual property cases are always interesting, no matter what. There's always something interesting about it. For one thing, it deals with real life. It deals with the stuff you understand. These with television shows and movies you've heard of, and books you've heard of, and the like. Not so much with patent law, but the Ninth Circuit doesn't handle patent law cases, so I was spared that. But generally, IP cases have high visibility and interesting facts. And the issues tend to be quite interesting, and graspable, the kind of things that don't get in, it's not like federal habeas law where you have to go through several levels, several layers of deference and exhaustion of remedies and things like that. So you get to the intellectual.
What do you have to prove to get it to win a copyright lawsuit? Let's say I've written a script and I think so and so has absconded with it. What do I have to do?
Well, if they really have absconded with it, then that's easy. I mean, if you had the script and they stole it, or you had the script and they copied it, and so on, and you can prove that, and assuming you were the original author or have the copyright to the, then that's pretty easy. You
have to show access and substantial similarity, right?
Well, if it's a carbon copy, you don't have to show access. I mean, if the script is word for word the same, access is presumed.
Yeah, I get it. But I mean, not every case is
generally, it's a lot less clear cut than that, where somebody will present a story, and then something else gets produced, which is sort of similar in key respects. And you think it's, they ripped off your script, and proving that is much more difficult. You do have to show access. You do have to show substantial similarity, and you have to show damages. And so they get very complicated because of the easy cases where somebody actually sort of copies.
Well, you recently did that a few years back in a movie called The Shape of Water. You were an advocate. Why don't you tell us about the specifics of that case?
Yes, in that case involved a script for a play that was written. It was about a sort of a dolphin that communicated with people, and there were certain parts of the script that were really quite close to scenes in The Shape of Water. The stories were different. They were they had some parallels, but they really were not the same story. But after the movie came out, many people wrote to the author
And
of the
said,
play and said,
"You were
"Hey,
ripped
wait a minute,
off."
you were ripped off. You were ripped off." So those are judgment calls. When it's a judgment call, generally these things get decided by a jury. The problem is getting to the point where the court will let you get to the jury. So you have to show enough similarity of protected expression to get to a jury. And that's where it gets difficult and
And
expensive.
in this case, you convinced the Court of Appeal that this was a legitimate
That's right.
issue.
That's right. Didn't convince them that there was, in fact, infringement, but it had been dismissed in the district court based on a ruling by the district judge that there was not enough similarity to go to the jury. The Court of Appeals, my old court, reversed.
What was it like to argue in your former court?
You know, it was actually surprisingly familiar. I mean, I had entered that courtroom hundreds of times and for oral argument. I was just in a different spot in the courtroom. It was the same kind of conversation. This time I was answering questions rather than asking questions. But it was surprisingly familiar and comfortable. I thought it would be much more jarring, sort of being in a different part of the courtroom, being the guy who is asking for relief. But it turned out to be quite comfortable.
What do you recommend for creators in terms of preventing plagiarism lawsuits?
Well, I guess it depends on which side you are. If you are the person that has the right or the person that's accused of that.
That's the person who has the right. I mean,
Yeah.
certainly they should register for copyright with the Copyright Office, right?
Well, as I understand it, that just bears on damages, but somehow they should document. I mean, it used to be that you used to mail a letter to yourself with...
Or to the Writers Guild,
Okay.
WGA.
Yeah, something that
Right.
involves...
Shows it was created at a certain time.
Yeah, now it's much easier to do, but yes, absolutely, you need to do something that will nail down registration is certainly good, but lots of things you can do to nail down that this is...
And you do get certain benefits, better potential damages
Yes.
and attorney's fees if you do register within a certain time.
I'm not saying you shouldn't.
Right, okay.
I think you definitely should, but if you haven't, it's not then reward because there are lots of ways of documenting that this is in fact your script. You can, but taking a conscious step at the time to protect it is an important idea. And as much as you can document your process, your creative process, if you have backdrafts and the like, that helps. It shows that you've developed the idea. This wasn't just something you sort of jotted down on the back of a napkin.
Judge, tell me about it's such a murky. We don't know what goes on in the closed environment of the judges. What was it like? How did the deliberative process work? And did you sometimes have yelling matches, serious violent arguments, or was it all very calm and dispassionate. And how often did you change your mind because you were persuaded by another colleague?
Very seldom. I'm in my 30-plus years in the Ninth Circuit, I saw what I would call sort of violent or heated arguments a couple of times, maybe.
Well,
But the judges get together physically only for the oral argument and the conference afterwards. Most of the persuasion happens by email and memorandum, and so there's not sort of that personal interaction. Judges, I changed my mind a few times on cases, not very often, but occasionally. And I think I managed to change minds of my colleagues more often than that. It was all very civil, but again, with a couple of exceptions where people really got mad at each other. But that was really rare. And it was a deliberative process, and in the end, you have to come up with something that's public. I mean, if you disagree, somebody has to say, this is my position, and somebody else has to say, this is why I disagree. And you both sort of put yourself out there to the public, and the mind you have is, is the public going to see what I'm saying is stupid?
Well, two more questions. One is that you're famous for the case of U.S. v. Sufi Enterprises in 1990, where you used 215 movies as puns in an argument you wrote talking about monkey business in that case and a platoon of Goliaths and the splash that happened and the Titanic bidding war.
Yeah, and the first word of the opinion is suspect.
Oh, suspect, right.
Yes. That was an antitrust case brought by the Justice Department against a chain of movie theaters in Las Vegas because, they were sort of worried that if people couldn't go to movies, they wouldn't have any entertainment in Las Vegas. Consumers would get...
well, arguably the most entertaining opinion in history. Now, you brought a book. You want to tell us about that book that's here?
Oh, well, can you read it all? It's Romanian. It says, "A început în la Bucharest." It started in Bucharest. And this is a translation of a bunch of my opinions and speeches into Romanian. I didn't do it. There's a scholar in Moldova. His name is Tudor Papuk, and he translated it to those opinions into Romanian. And I was back in Romania last October attending a conference that I well attended at the law school there, launching the book. But I thought
I love it. And I love having had Judge Kozinski here. As you see, he's had a remarkable career and highly intelligent and extremely charming. I want to thank all of you for watching Tune In with Trevor and ask that you follow us and write good things about us. See you next time.